statement. This case management conference hearing is in the matter TCD 009-2020 before His Excellency Justice Nasser al-Nasser and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant's lead counsel is Martin Hoshdell. The defendant is represented by Charles Russell Speechley. Lead counsel is Thanos Carvallis.
Thank you. Welcome. Mr. Martin, you may start, please.
I apologize, Martin. You're muted. You will have to unmute.
Sorry. It's a bad. Good morning. This is the case management conference. In two cases, you should have two bundles, but to confirm the case numbers, it's TCD 009-2020 and TCD 003-2021. There are essentially can I
I think there is an issue with the connection.
Yes, I think I've got Wi-Fi issues. I'm actually wondering if I'm able to dial in manually from a phone, because I think my Wi-Fi is going to be problematic.
Just a minute. Mohammed, can you check if the claimant can dial in?
Yes, Your Honor. I'm just contacting the IT department now. Please hold.
Morning. Can you hear me?
Yes, I can hear you.
Thank you. Apologies about that. I will, Your Honor, if you're content, I'll start again, and we'll pick up where we left off. I should say, so I represent the claimant 5 real estate, and then Mr. Thanos Carvallis represents the defendant Reem Emirates aluminium. As I was saying before, there are two cases before you. There is TCD 009-2020 and TCD 003-2021. And what I was going to propose for the purposes of the case management conference today is to just briefly, very briefly, touch upon the background and where we're at today. You would have probably seen already memorandums filed by both parties, which regrettably are not agreed, but hopefully we can get through them with relative ease this morning. Dealing with 009 first, the 2020 matter, this was a claim initially filed by 5 for various claims, which I'm not going to go into the details of, because following a defence and counterclaim and replying further pleadings, Reem eventually sought to strike out the claim by 5. Essentially, after many applications later, 5's claim TCD 009 was struck out. It has been struck out and remains struck out, so therefore there is no claim by 5 under that case number. What remains under 009 is the defendant's, as in Reem's, counterclaim, which you would have seen in the bundle in relation to that case number. And what you'll see is essentially, and I am very much paraphrasing, so I hope my learned friend doesn't think that I'm trying to avoid the issues or anything, but what it essentially amounts to is a claim for various sums which were not effectively paid were not effectively sanctioned by the engineer. What that claim in essence will amount to, broadly speaking, amongst other issues, is whether or not there can be a successful challenge to the engineer's decision. TCD 003 is a claim by 5. There isn't a counterclaim in that. TCD 003 pertains to the indemnity between the parties, where the defendant will indemnify costs, damages arising out of, as a suggested, delay, defective works, etc., as well as any losses by the owner, which isn't 5. So that's broadly, very broadly speaking, what the cases are generally about. As I say, you have seen memorandums which have been filed by both parties respectively, regrettably not agreed. But what is agreed, and what I understand my learned friend's legal team will be able to do, is to show you the agreed order, albeit in track changes. So in terms of what we're going to be doing today, hopefully you'll agree with the timetable that we have jointly suggested, and make any suitable directions that are required.
Okay.
I don't know if at this stage you want to hear from a learned friend, just to ensure that we're all on the same page, as it were.
Again, please.
I was saying I don't know if at this stage you want to hear from my learned friend, just to understand, just to ensure that we're all on the same page.
Yes, yes, I do want to hear from defendants.
Good morning again, Judge.
Morning.
I would agree with my friend. It is indeed a very broad description of the dispute between the parties, but it is to a great extent accurate. The only point that I would add is that, considering the nature of the claims in TCD 9 and TCD 3, i.e. in Reem's claim, which is the TCD 9 matter, and 5's claim, which is TCD 3 matter, as it stands today, the resolution in TCD 9 should impact heavily on the resolution on TCD 3. Because of the, as I said, because of the nature of the claims, of the respective claims. What I mean by that is, this may be interesting for when we will discuss the issues in this case. If Reem is found by the court to be indeed entitled to an extension of time, and regardless of whether it will be also entitled to prolongation costs actually, then this alone should result to TCD3 matter falling away, because it presupposes the liability of Reem for delays in the project. That's the only thing I would like to add. As my friend explained, we did manage to agree a draft order with a timetable, which is obviously subject to your approval, which I believe my friend sent to the registrar just before, or a few minutes ago, and we can go through it and make sure that it works also for the court. The issue that the point that it is not agreed is the list of issues. Unfortunately, we have not managed to agree on the issues in either matter. Actually, on this, we respectfully request the court to adopt the list of issues that we have made available in the case management bundle, which I'm happy to walk you through if necessary, which in our view, it's comprehensive. It addresses the issues of both parties and should be able to assist the court and the parties in the subsequent stages in this process.
Okay. Anything from the claimant side?
Just on the order, it hasn't actually been sent just yet, because of my internet issues. I don't think it keeps getting bounced back. So I will send that through shortly. Broadly speaking, I agree in the sense that there is a commonality between the claims, in that who is responsible perhaps for the delay. There is that issue, because once that's determined, then a lot of the other issues will probably fall away, or consequentially fall away. But to that extent, there is that commonality between the cases. It should also be said that the reason why we say that as well, you'll see in the order that we are both parties agree that both cases should be consolidated. So that will deal with that in terms of procedurally and dealing with the merits together. I'm happy for my learned friend to take you through the list of issues. It's not agreed, but only in the sense that I should say that Al-Ada as the firm has only come on board a few days ago. So there is a bit of catch-up being played here on my end, but I will try to assist the court as much as possible when we go through the list of issues. But if you bear with me on the timetable, I will get that to the court as soon as possible.
So the timetable both parties agree on?
Correct.
Yes, Judge. It has been agreed. If my colleague, if it would help, we can send it right now. To the registry? To the registry.
I'm very grateful to my learned friend, Mr. Kavelis. I would appreciate that, because I've got internet problems on my side, so I don't want to hold up the court.
No worries, we've all been there.
As long as both parties agree on the timetable, the courts have no issue, except probably the date of the trial might differ depending on the court's availability on that date. But other than that, this can be also discussed later on at the PTR.
Yes, just so you know, just so Your Honor knows, right now the proposed trial date is the 26th of June with a time estimate of 4 days. So I don't know if Your Honor is at the moment aware whether or not that such a trial listing would be available or would meet with the convenience of the court. But I only let you know just in case you're able to inform me.
Yeah, the registry will confirm the trial date. But other than that, if the parties agree on the date set going forward from today, I don't think the court have issues with the schedule provided by the parties or accepted by the parties.
Yes.
In relation to the list of issues, I think maybe we can go through them.
Yes. The only other way I can see perhaps maybe dealing with it is if, because we've only come on board, as I say, a few days ago, we haven't had the chance to properly grapple with the case as such. The only other suggestion I was going to make is, because the parties have been able since to agree the timetable, and if that's a good precedent, then we may be able to, between us, agree a list of issues and facts for determination. But as I say, I am in the court's hands. If you want to look through the issues now, then I'm happy to do so as well.
If the defendants agree that you just came on board and there is room for discussion to agree on a new list of issues, the court doesn't mind, definitely.
The defendant does not disagree. It is a sensible proposal by by my learned friend, and we would like to hope that we can have an agreement now that my friend is involved in this matter. The one point that we would insist, though, is that this does not delay this case management conference. It is concluded today, this case management conference, and the order, at least in relation to the timetable and any other directions that the court would be mindful to give, is issued today. You would very much insist on that, Judge.
For my part, I have no problems with the case management conference concluding today, with the timetable being issued today, subject to the parties providing an agreed list of issues if possible. If for some reason that can't be done, and I hope it doesn't get to that stage, because I am hopeful that we can agree a list of issues. If it weren't, then the matter would need to return to court just to deal with that point. But I don't think that will happen. So I agree with my learned friend that we should have the timetable issued today so that the timetable starts, as it were.
So what's the defendant's position?
We are hopeful also that now that there is a counsel acting for the respondent, we will be able to agree. As I said, let's have the order issued if the court agrees. If the parties, in the unlikely case that they cannot eventually agree to the list of issues, we would respectfully request the court to issue an order directing what the list of issues will be. And we respectfully request that this list of issues are the list of issues set out in the bundles, the case management bundle for TCD 9 pages N November 23 and N 24, and for TCD 3 again the case management bundle pages 9-3, only one page. And that they are consolidated, and they are consolidated as one list of issues, since, as my friend mentioned, that I forgot to ask also for the defendant, we would like the two cases be consolidated. They are indeed, there are commonalities that make sense for the efficiency of the trial, that the cases are consolidated. So the list of issues should be one, I guess.
Okay.
Your Honor, it's, can I just make one minor counter proposal? I hope it meets my learned friend's approval, because I don't think it will be problematic. If in the event the parties can't agree list of issues, may I respectfully suggest that the parties provide their versions of the list of issues to the court, instead of the court having to look through all these bundles and papers to find the list of issues? Because I think it will just be easier for the court if, say, for example, my learned friend.
It's much better if the parties don't agree on a list of issues. Each party presents his own list of issues.
Yeah. So if my learned friend agrees, then we can just do. So if, for example, I'm just saying, for example, 2 weeks time, 3 weeks, 4 weeks time, we can't agree a list of issues, each party just provides this list of issues to the court for the court to just determine and merge together, or do as it wishes. And so if my learned friend agrees, then I think that might be a sensible way forward.
I have no disagreement, Your Honor, with my learned friend's suggestion. Just one minor point. We need to make sure then that in the order that the court will issue today, as discussed, we make an allowance in paragraph 1 to an agreed list of issues, or if not agreed, to at least to the respective list of issues.
Yes. Can I just inform my learned friend I've got no problems with that. So if he wants to insert that, send it to me and I'll have a quick look and we'll agree it and send it to the court eventually.
Thank you.
Thank you. So I think it's clear now that the parties send a draft TMT order, which both agree on. The courts will approve and issue the order. And in relation to the list of issues, the parties will discuss. And if they agreed on a list of issues, that's excellent. But if the parties fail to agree, each party will present his own list of issues to the courts.
Yes.
Your Honor, one minor point which I should not forget. Yes, we have agreed that the trial will commence on the 26th of June, and the estimated period of the trial is 4 to 5 days. We would think that let's allow for the 5th day in the calendar now. We might not need it, but just in case.
Okay, no problem. Anything else from both parties?
Not from my side, thank you.
No, Your Honor.
Thank you both. Well, the courts will be waiting for the draft TMC order. Okay?
Thank you very much.
Thank you.
So is
And
this
apologies
concluded?
again. Apologies for the internet issues again. Sorry.
Just for the record, is now the case management conference concluded?
Yes.
Okay. Thank you.
Thank you very much.
Thank you.